Hi everybody. Just as we let all the attendees join in, if you can perhaps raise your hand just to show that we can see or that you can hear us. Excellent. Thank you, Robert. That's perfect. All right. So it's just ticked over 12 o'clock, so we will get this started. So firstly, I'd like to welcome Ben Plale along, who's joining me today from SuperGuardian. And as you know, I'm Tim Miller from Smarter SMSF. So thanks for joining me today, Ben.
All right, thanks, Tim.
And what we're going to be talking about for the next hour is this concept of demystifying the SMSF documentation. Now, I actually think, Ben, what we may end up doing is providing more food for thought than anything else, because as you appreciate with a lot of the questions that we've had from our time of working together, is there's always challenges, there's always documentation that clients are after or needing, potentially, whether it's just from an administrative or from an audit point of view. Would that be correct?
Yeah, definitely. Yep.
Yeah. So look, I think the reality is that what we're going to do is try and work through a number of these key issues for you. And by doing what we plan to do, we're going to work through a list of the documents. So we'll sort of run through at the end, providing all of the SIS requirements as far as documentation is concerned, and what we might need to be considerate of there, but also the sign-in requirements. And this is one of the questions that I know that we get asked a lot from an administrative point of view, which is, can we sign things electronically or not? And so we'll work through what we definitely can and what we definitely can't do from an electronic point of view at the moment. So we'll touch on that, and then we'll also finish off with the record keeping requirements from an SMSF documentation point of view, because again, these are often legislatively driven. So we'll also consider various risks associated with documentation, and in preparing for this, we sort of the conversations that Ben and I were having. We've only got an hour, so we can't go through every problem client that we've ever had in regards to the various risks associated with it. But we'll touch on a couple of the key points, and then what the future might hold with regards to some of the documentation requirements. And in particular, there, what I'm going to be looking at is the idea of wet ink versus electronic signing, because it's fairly limited as to what we can actually do at the moment. So just one of the areas there. But I guess that's probably one of the questions you get asked a reasonable amount, is how can we sign this document?
Yeah, definitely. Yep. And then electronic documentation, I think government legislation is far behind where industry in reality is.
Yeah, absolutely. And I think that's probably one of the key things that this is a sentence I don't particularly like to say, but probably one of the good things that COVID brought to us as an industry was I think it escalated the need for things such as electronic signatures, and when people couldn't get together, we saw what that actually resulted in with reference to capacity to sign some
yeah,
things.
definitely, and a challenge to the status quo, and it's like, well, can we do this better, or can we do this differently? So I think it's really led the way in that regard.
Yeah, good. And so we'll look at some of the legislation elements associated with that as well. So look, one of the things, and what I did as part of this presentation is I went back through a lot of the work that we've done as well with regards to Smarter SMSF, because we are a document provider. So in addition to education, we do have a suite of over 80 documents, obviously including trustees and things. And so as part of our ongoing webinar series as well with our clients, sort of we've addressed this documentation issue a few times, and so there's a couple of webinars where we've actually polled the attendees, and so from our webinar back in June 2022, and as you can see there, we had over 300 respondents to that webinar, and the need for your documentation, or need for documentation with your SMSF clients, we asked 4 questions: is it decreasing, not changing, increasing, or significantly increasing? Now, obviously, putting the emphasis, putting the mayo on it as such, by going from increasing to significantly increasing, what we're noticing there is that pretty close to 80% of funds, they've got an increasing need for documentation. What is not staggering there is that 0% of respondents responded that their documentation need is decreasing. So it's clearly one of those key issues that we need to be aware of for our clients, because whether it be for audit purposes, or more to the point that there's far more, I guess, litigation and challenges with regards to estate planning that we see in the industry that I suspect will mean people need to go back and check on their pension documents to make sure that they're all, not just their pension documents, sorry, but all their documents to ensure that they're satisfying all of their requirements. So, that was one of the key issues, and so I guess what that sort of led me to be able to deduce from all of that is that, without a doubt, there's this historical gap in the provision of technical SMSF documents across all elements. So whether it's the legal, the SIS, or the tax compliance. And, I started in the industry in 1999, and it would be fair to say that in many instances, pension commencement documents haven't actually evolved a great deal in that time. I think there's been some element of people trying to pad the documents out and make them broader, and I think that's a really positive move. But generally, we've always taken a minimalistic approach to these sorts of things, and probably the classic one for me is investment strategies. And in the very early days, we used to often hear comments, and I used to make them myself. The investment strategy is not worth the piece of paper it's written on, and you'd cop some negative commentary about that. But ultimately, because there was no real regulatory push for the investment strategy to mean anything from an SMSF point of view, most people didn't put any time or thought into it. But now, from an auditor point of view, auditors are looking closely at the investment strategy. The tax officer obviously then taking on board commentary from fund auditors. And we've seen with things like LRBAs where that 17,500 funds were issued with please explain letters because they had an investment strategy that basically had 100% or between 90 to 100% of their assets invested in a single asset, so there was no diversification. So the ATO just wanted to know, well, what is your diversification strategy? What are you trying to do? So, this concept, this gap that existed from the past to now, it's still there, and hopefully we can see people sort of narrowing that gap and becoming more technically competent in the content of documentation that we're providing. So again, that leads to the concept that there is an increased focus on documentation from a legal and compliance risk, and BDVNs are probably the most critical one there. But there's not too many SMSF presentations you attend these days where it doesn't start with read the deed. The whole idea of working out what actually needs to be said, because everything's fine until it's not. And the issue with self-managed super funds is that the biggest challenge we tend to get is when trustees are going along swimmingly, then it doesn't matter what the documentation says. But when someone in the family or when somebody else wants to challenge a transaction, then that's where we run into issues. So again, the expectations, a lot of that comes back to what the tax office and the auditors want to see. And I think this is part of the issue, and it's not really an issue of the SMSF software providers. So I sort of give them kudos for providing some form of template basis from a documentation point of view. But then those that are using the various SMSF softwares to do their SMSF admin, and I'm guilty of this. I run my own fund on an admin platform, and occasionally I will just go and use the template as a starting point. And then try and build out there. So, without putting you on the spot, Ben, how often are you asked to create documents from a trustee point of view to meet their compliance needs?
Oh, it's fairly regularly.
Fairly regularly. Yeah. And do those questions come from the trustees, or is that based on scenarios that are driven by the fund auditor?
Bit of both, but yeah, often increasingly the auditor in terms of decisions are being made, often prepaid rent or things like that.
Yeah,
making sure decisions are documented well beforehand.
Yeah,
or as they occur.
And that's and it's really I guess it's a really critical point there, is that from an accounting point of view or administration point of view, what we're trying to do is we're trying to get the fund prepared for audit and understand the transactions as we see it based on the information that we've been provided. But then the auditor, they have to undertake an analysis of the fund to make sure that all the transactions meet the sniff test and things like non-arm's length income and other things. So, they are the final set of eyes to say, yep, this fund is meeting all its conditions. So, the reality is we're put in a position, both as trustees and administrators, where we are having to produce more information and there can be a significant cost associated from a documentation point of view in some instances, and in others they just want a confirmation. And so as you've done, you take a base document and you state what the auditor needs to state, or what the auditor needs to see, so long as you're not crossing any legal sort of boundaries and things like that. So, I certainly know you're not out there drafting up trust deeds or anything like that, but just confirmation minutes.
Yeah, it's confirmation minutes. Yep.
No, it's good. And so it is that whole concept of juggling this concept of creating documents like Ben and I have just spoken about, and then importantly, aligning that as much as possible to the trustee of the fund. And because there are so many documents that we can go through today, we'll sort of touch very quickly on a couple of the key issues around some of those moments or some of those issues. And then with others like pension documents and binding death benefit nominations, we'll go perhaps a little bit deeper into some of the situations there. But one of the areas that I will address is obviously the change of trustees, and when we talk about risks and things like that. And again, it's when we go about the process of changing the trustees of the fund, adding it or removing a member, yes, we come back to what does a deed say, but then, what is the preferred practice, and, is a deed amendment better than a trustee resolution? And the short answer to that comes in, well, it's going to come down to what is the end result with regards to if there's ever a legal challenge in it. And I've got a great example that I'll touch on when we talk about pension documents shortly. But you'll notice there from that, also from another of the webinars we did going back to 2021, when we talked about who creates the documents themselves. You'll see that there's this relatively even split between the various people that go and generate the SMSF documentation. So all things that we certainly need to be mindful of. But what I wanted to start with, and I'll try not to be too technical in too many elements here, and keep it as sort of practical and thought-provoking as we can. But I thought this LSIL Proprietary Limited Fund or scenario that we were speaking about recently on our SMSF day really gave a really good position as to the importance of fund documentation, but also the importance of being able to create a document trail. And so when we're talking about record keeping, whilst we have certain conventions and requirements that we need to meet, it's pretty important that ultimately, to me, we keep documents, certain documents such as a trust deed, for as long as we can, and because the number of clients that come and say, oh, we've lost our deed, or we can't find a copy of it, and if you take over the administration of a fund, that can be pretty problematic. But in this case, just really quickly, so LSIL was the trustees for Daycom Communication Proprietary Limited Super Fund, and they were looking for guidance from the courts because they couldn't find the original deed back to 1979. There were other deeds that were identified, but there was not enough to be able to, I guess, certify that their appointment as trustee in 1996 was done in accordance with the requirements of the deed. So, it had been done in accordance with the deed from 96, but they weren't sure whether it had met all the conditions of going back to when the fund was established. And of course, the final copy of the deed that they had was one that was upgraded in 2015. And in this instance, the clients had created binding death benefit nominations in accordance with that rule. And so what actually the courts decided here, or they relied upon a thread, and they looked at the evidence to first establish that there was an establishing deed of the fund, which was 1979. So they are actually able to look at the chain of events through all of the deeds, so the 1989 deed, the 96 and the 2015, and from that the courts accepted that the establishing deed was validly executed, so that first deed was done correctly. And then, despite there being some issues potentially with the 2015 deed, that it could actually be relied upon to be the operative deed for the fund. So why is that valid? Well, it's valid because in this instance, we're talking about a death benefit, and the death benefits were done in 2017. And so, of course, then once we're paying out a benefit under or in accordance with those death benefits, we want to make sure that they have been validly executed. And that's really probably the crux of a lot of these issues is when a matter comes up or has to come up before the courts and someone's wanting to challenge it, the first thing they're going to look at is the deed, and then they're going to look at any other supporting documentation. So if we've just got loose pension documentations, if we've got loose binding nominations, how does that fit in with the entirety of the history of the transactions of the fund to determine whether those documents, one, are legitimate, and then two, what do they actually mean for the various parties to the court case. So I thought it was an interesting one because what this case was able to prove was that despite the fact that the 79 deed couldn't be located, that the courts were comfortable that because of the history, the 2005 deed was valid, and ultimately we didn't need to now go back and refer to that other deed to be able to make decisions of the fund. So, I think that there's a number of issues for us to be mindful of with regards to documentation and certain risks associated. And these are all sort of common, I guess, common sense in some ways, but they're not always going to be common sense in the situation of how trustees are thinking, because trustees tend to think in the moment rather than historically and forward thinking as well. But if we go through these sort of and I'm not going to go through every point obviously, but just highlight some of the key ones. If we look at our estate planning documentation, we need to ensure that our binding death benefit nominations are valid or not. So do they follow the process? We won't spend too much time on that because I'll come back to binding nominations shortly. Similarly with reversionary pensions, do they exist or should they exist? Do they conflict with the BDBNs? And if they do, what does the deed say in regards to what takes precedence? And then there's always a little bit of a conversation piece about that. Deed and other legal documents, have any deed upgrades, are they effective, like changes to trustees? Are they outdated? What about the consistency with the constitution? So does the deed and the constitution, do they marry up with each other with regards to things like appointment and removals, the special purpose requirements? So, and again, then this concept, which we'll talk about a little bit later, on the electronic execution versus wet ink, and what we do know is that deeds largely can be executed with an electronic signature as a result of COVID, but in an SMSF environment, there's a lot of other things that can't actually be undertaken. So yeah, all of these documents are fairly critical, and I want to just touch on that point about the deed and other legal documentation and talking about changes to trustees, because as I said before, and I occasionally sound a little bit like a broken record with these matters, but when we're talking about appointment and removal of trustees, which is a fairly significant transaction, some deeds are very strict that it has to be done by a deed amending deed, so a deed of appointment and replacement. So we actually have to go through the process of getting a document prepared, a deed as such prepared to do that by the lawyer to undertake that, versus the trustee resolution. Now, this is always a bit scary because from a trustee resolution point of view, it means that the trustees just resolve, so they just prepare their own minutes to appoint and remove the party. Now, that might make things sound administratively a lot easier, but has it then been executed appropriately? And I think they're the areas that people need to be mindful of, is just because the deed provides this avenue to simplify processes, is it better to go down that path, or are we better off actually looking for in a more stricter sense, going down the legal approach of having the original deed reviewed by lawyers and then the deed of appointment and removal performed by those same lawyers?
Yeah, and I had that the other day actually, where someone was trying to do a trustee resolution, but then they ran into the trouble whereby the bank wouldn't accept it. So when they're trying to update the trustees for the bank account, the bank like, well, this is not a formal legal document, and so they'll force it, even though the deed allowed them to do that. The bank forced them to. We need something more formal.
And I think that's the bit that we often forget in the sense of responsibilities and ongoing obligations, is that we go, oh, it's easy to do this trustee of appointment and removal by a resolution, but then what other third parties are we dealing with?
Yep.
And in this instance, it was the bank. It might, in another instance, be conveyancers. It might end up being, family law from a relationship breakdown. So, what are the consequences of the transaction? Because I know the pain points of potentially dealing with the banks with changing trustees, with death benefits and other things like that, as well as sometimes they'll just freeze the assets if the names don't match. So that's a really solid point that we need to identify, is that it's not just because something's easy that we do it. It's what are the ongoing consequences of it. So resolutions may not necessarily satisfy the conditions. So again, then things like related party transactions, and I did a webinar recently about dealing with related parties, and I really think it's one of those areas that we have to make sure that we document everything as well as we can, because we want to make sure, one, that we're meeting things such as the in-house asset rules. We do know that from an in-house asset point of view, if the fund has breached its in-house asset levels, that it has to prepare a written plan. So what does that written plan actually look like, and has it been provided to the auditors, and are the trustees sticking with it? So it's one of the few times in the legislation that it does talk about preparing a written plan to do things. So,
and often around that area, related parties, that's where you're going to have increased documentation, because the auditors are wanting to scrutinise to make sure everything's above board arm's length arrangements.
Absolutely, and when in a moment I'll touch on limited recourse borrowing arrangements as well. But loans to related parties, leases to related parties, even when we're talking about business real property,
rent in advance.
Rent in advance is a great one, and Ben and I were speaking about that recently. Of how do we document a situation like that? So it's not to suggest that these things aren't possible or acceptable in a trustee space. It's just whether or not the documentation matches up. So is it mentioned within the lease, and if not, what are the terms of the lease that need to be changed, and how do you go about changing that, which is all additional work and an additional burden on the trustees, but non-compliance is an even bigger burden on the trustees, and so we want to make sure that we're meeting the requirements.
And it's just being aware of that, because so people often go into related party transactions like with businesses or rentals, but it's just being, and it might be a good move for them, but they've just got to be aware that it also comes with an extra documentation and compliance side that often trustees don't particularly want, but that's the side effect of it.
Yeah, and look, and I think that's again, without jumping off onto a related party subject matter, but even the idea of like loans and financial assistance, because it's one of the biggest breaches in the SMSF space. And then people say, well, actually, I legitimately can loan money to a related company. It's like, well, yes, you can, but you want to make sure that the documentation is tight, because otherwise, it is borderline financial assistance if it's a bit flimsy in any of the compliance support that you provide with it. So it is certainly an area that, if we're trying to meet our obligations, we want to make sure that we're doing the right thing. So I think you raised a really good point there. And when we talk about things like investment strategies, the risks, is it too generic to be effective? And again, this goes back to my not worth the piece of paper it's written on. In my early days of administration, the investment strategy used to basically just regurgitate the law. Now, I think where we've got to is that that's not an acceptable investment strategy, because it's not saying anything. All it's saying is, well, here's what the regulations say, and I've just signed it. We need to be a little bit more specific in that, and I think that's an important area. And as we then move forward and talk about such things as non-arm's length income, the whole documentation of fund expenses, I think, is going to be a critical issue to undertake. Why are trustees doing things and undertaking certain transactions? And I think probably the obvious one there for me that comes about is the off-market transfers. So by undertaking off-market transfers, what does that actually mean with regards to the consideration that we're using, and how much of it is a purchase and how much it is a contribution? And I talk about it with property transfers under the NALI ruling that came out recently. So have we got all of those sorts of things aligned correctly? So just so many risks associated with it. LRBAs, again, the loan documentation, the bare trustee documentation, all these sorts of things should be drawn up by appropriate legal parties if you're going to go down that path. And then the pension documents. So does the documentation exist? Can't be found? Again, one of the things that has always intrigued me from an administrative point of view, when you take over a fund and you ask for the pension commencement documents to be provided, and it's, oh, we haven't got any documentation. So, well, then you don't have a pension, basically. I mean, how have the trustees identified that pension started? How have they confirmed the request from the member? And I'll go on to a lot of that sort of stuff in a moment. But and then this last point, which I'll touch on in a sec, is a product disclosure statement should it have been issued. So look, let's jump into pensions, because I'm mindful that I've got a fair bit that we want to get through today, and we could talk about all the mistakes that happen for an infinite period of time, but we need to sort of identify some of the key issues that we need to be mindful of. So one of the things, when does a superannuation income stream commence? And the ATO's reference from tax ruling 2013-5 must be determined by reference to the terms and conditions of the super income stream agreed by the trustee members, the rules of the super income stream as set out in the governing rules. So what does all that actually mean for us? What are the things that we're looking at? So when we're talking about these terms and conditions, what are they, right? So if we just go to our software provider and we produce a minute, and that minute says that Ben has requested of the trustees to commence a pension, and the trustees have started that pension, right? It's not really identifying any of the terms and conditions, and even to the extent that the deed and often many of the older deeds will simply say something like, you can pay a pension in accordance with the law. Now, if that's what you are going to undertake, then your documentation around that should at least be referencing the clause in the deed or the section of the law that the terms and conditions are meeting, because the pension standards will identify that you must pay the minimum pension. The pension standards will identify when a pensions can and cannot be commuted and all those sorts of things. So that can be your terms and conditions, but how has that been referenced? So what sort of transactions has the fund undertaken from its documentation point of view to ensure that there is that direct link back to the terms as provided for by the law? Or are you going to be more specific? So a pension might be commutable, but only to a certain percentage. A pension might be reversionary, but only to a certain percentage. So there's no law that says reversionary pensions must be 100% reversionary. And in light of things such as the potential government announcement about this $3 million high income or additional income sort of tax measure, are we looking that reversionary pensions might not be down the path that we want to go? And we don't know enough about that new measure and its link to death benefits to really work out what the right process is. But so all of those sorts of things really come down to what we and how we document the terms of the pension. But I wanted to touch on this one here about the pension product disclosure statement, because the question's always been asked as to whether or not you need one. Now, where we sit is that the Corporations Act does require a PDS to be issued when a member converts from accumulation to pension, because pension is a product. It's a new product, so there is a requirement there for a PDS to be issued. But there's this limited exemption that exists, and I make sure I get the wording right here, that if there is reasonable grounds to believe that the member has received or has and knows they have access to all the information that a PDS would require to contain, then you don't need to issue a PDS. So that's basically making the assumption that the member is fully aware of all of the rules associated with all types of pensions, and particularly the type of pension that they're actually being paid. And I think that's a massive assumption to make, right? Despite the fact that all trustees sign a trustee declaration that states that they understand their responsibility as trustees, that's them as a trustee. As a member, yes, same person, different hat. Do they understand the intricacies associated with the pension? Do they understand the commutation rules? Do they understand the ramifications of not paying the minimum pension? Do they understand the tax implication pre-preservation age, as minimal as that might be now? But do they understand what happens if it's a death benefit income stream and everybody was under the age of 60? So there's all these sorts of things that you would argue that in most sets of circumstances, the member doesn't have access to all that information, and so therefore, it's a far better process to ensure that a PDS is issued than to make an assumption on behalf of the clients that the PDS is not required under the exemption. So I think it's one of those areas that we certainly need to be mindful of, that in addition to our pension contract or pension agreement, whatever it might be, in accordance with the deed, whether the deed requires that or not. So whatever our pension commencement material contains, then in most instances, I think a PDS is a valuable document to provide in addition to confirmation that the pension has existed. And so the things that a PDS might include be the types and the term of the pension. So again, we might have somebody that's going from a complying lifetime pension. Yes, very few and far between now, but they might be going from a lifetime pension to a market-linked pension, the terms of which are both quite different. So they need to understand what the terms are. They might have an existing market-linked pension that they're looking to commute and change how long that's actually payable for. So what are the term issues that they need to be mindful of? Any other admin requirements, any tax and actuarial considerations, the advantages and disadvantages of the pension. Again, a market-linked pension is a good example to highlight there, because the disadvantage is non-commutable. You can't take a lump sum benefit down there or not. So whether the pension is commutable or reversionary, and then the estate planning implications of the income stream. So there's a lot of information that we need to be able to provide to the members upon commencing a pension, so they're au fait, I guess, with what's actually going on inside that income stream. And we. And this is a dangerous slide to put on. It's always a dangerous slide when you put that one purple word on the screen. And one of the things when Ben and I were prepping for this the other day, it was like I said to Ben, whatever we do in the presentation, let's not use the word backdate. And then I went and put it in a slide and said, is it okay to simply backdate the pension documents to the commencement date? In a one-word answer, Ben, what would your answer to that be?
That would be no.
That would be no. Okay, so this is again one of those key issues that I 100% agree with Ben's answer there. So luckily we haven't come in here with the controversial position changes on yes versus no. What we have to be mindful of in this space is that, again, we look at this TR 2013 ruling that the ATO released, and it talks about when a pension commences and when a pension ceases. And one of the key things about it commencing is that it can't commence prior to a time when the member requests via an application. It also goes through in some detail what that application date might actually look like. Now, for SMSF trustees and members, what we really ultimately have to distinguish between is that request to commence a pension doesn't necessarily need to have all of the details finalised, like what is the exact member balance at that point in time and things, because we know administratively a lot of that information isn't going to be available. But it's that decision that the trustees make, and then we can ratify that decision, and then we can provide further information about that decision at a future point in time. But it's ensuring that when we're talking to members and of the fund and obviously trustees, that we are identifying, if you want to start a pension on the 1st of July, then you need to have made that decision prior to or at the 1st of July to start that. It's not a matter of going back and saying in sort of towards the end of the financial year, oh, it would have been better for us to start a pension back then, because then you're past that period of time. So, the capacity for members and trustees communicating with themselves, which sounds odd when they're the same person, but the capacity for them to effectively report that concept, and often that'll be in conjunction with a conversation with their whoever their SMSF professionals are that they might have potentially appointed to provide that advice piece, to at least have documented that the plan is that we will start a pension on this date, right? Acknowledging that we won't have all the information available to us at that point in time, but at least being able to put that documentation in place. So, as administrators, I guess that's one of the key things that we had to be mindful of, is that we're always working in arrears in regards to putting together the documentation for a pension that's started, But it's important that the requests come through in a timely manner to say, okay, this is the decision that's been made, this is the date that we wish to commence it. We appreciate that payment doesn't need to be made immediately, but it's the starting point for our pension. And now, of course, with the transfer balance account as well, we're going to move from 1 July 2023 to a quarterly reporting requirement. So the whole idea about the idea of backdating pension commencements and that almost becomes a moot point from a regulatory point of view, because the tax office have already provided enough indication that they're actually going to start penalising people for late lodgement of T-bar as well. So if you're not lodging in that quarterly basis, then you could find administrative issues from a fund point of view. So always things to be mindful of.
Definitely, and that's forcing that quarterly reporting. Just forces the industry to be a bit more concurrent with its approaches with starting pensions and informing and things like that. So
and I think it's a good thing. I mean, honestly, I think it's a good thing, because the other thing is, if you don't report on time, and if you do have situations where you roll money over, trying to unwind excess transfer balance account issues and things like that can just be hugely problematic. So I think it
makes it a lot easier as well, because at the moment, like, some are on annual and some aren't, and if you haven't done the accounting back at the start, it's hard to know. So
that's right, and particularly if you've got a minimum obligation too, you want to get to the process and get these funds administratively up to date as soon as possible, so that you're not going to end up with a pension shortfall based on a false valuation. And of course, without going down a path of talking about asset valuations, but valuations from a pension commencement point of view is clearly a critical point to make sure that we're reporting the right amount of money. Now, again, I'm not going to read all the words on this slide, but what I wanted to highlight here is that your stock standard pension documents are not going to accommodate things such as what you do with drawing in addition to your minimum pension. Right now, I have no doubt that we have a lot of situations that you'd come across them on a regular basis, particularly at the end of the financial year, where clients are trying to determine how to best treat their payments over and above any minimum obligation. Now, that's not going to be addressed in most pension commencement documents. It's an area that people need to start looking at and start contemplating, because of the ramifications it has for transfer balance cap point of view, but also for other reasons as well. But largely it's from an account or a transfer balance account management position. But it can have different ramifications if you potentially pre-2015 account-based pensions from a Centrelink point of view and other things. So this whole idea of saying that the client wishes to take the minimum, or at least the minimum, but without stating how much they're going to take, and that payments will be distributed at the trustee's discretion. So if you've got multiple pension accounts, that the trustees can ensure that you meet the minimum for each of those particular pensions as well. So providing as much flexibility inside that pension documentation is critical to ensure that, when it comes time to finalising the year, everything has been accounted for appropriately, and you're not all of a sudden going back to a situation saying, oh, we want to treat that amount from September last year as a partial commutation. You go, okay, well, you're now outside your reporting obligations from a transfer balance cap point of view. So if we're going to go back to the ATO and report that as a partial commutation versus a lump sum from accumulation, or as a pension payment which isn't being reported, then you can potentially run the risk of having, again, those same T-bar penalties imposed upon you for the lack of reporting at the time. So I think that, amongst other things, like reversionary beneficiaries, as I mentioned before, the strategy considerations that we just touched on there, but even things like asset segregation and who can sign pension documents. So, if we've got someone who's under a permanent capacity, does their EPA have the power to sign? And look, and this is where I'll pause and just tell a quick story. And this is a true to life story that occurred literally 2 weeks ago, maybe 3 weeks ago. Time sort of flies by. But I had a question raised to me, as I said, not that long ago, saying, Tim, we understand that you set up a pension for our clients in 2004. And the question that was being asked, and I said, it's very possible. I set up a lot of pensions back in 2004, and they said we know you're involved because you witnessed the trust deed of the fund when that fund was established in 2002. One of the members has passed away, and the question being asked of me was, do I have copies of the pension documents that were set up by myself in 2002 for those clients? Now, of course, my answer to that was no. I don't have any copies of the pension documents because, as an employee at the time, my obligation was to prepare the documents in accordance with the client's wishes, and then those documents would be stored with the fund's record, and then the fund left that administrator in sort of pre-2010 time. So I hadn't even been a fund with my previous employer. I hadn't been with them for almost 15 years, but they couldn't locate the pension documentation. Now, the issue was because the member had died, they wanted to determine whether or not that original documentation supported the pension being reversionary or not, because there was a challenge because the will said to leave the money to the son, whereas the wife, who was the surviving member, was saying that she wanted to be paid the benefit. And this is the problem that documentation or lack thereof can create. Now, what I said, look, obviously I don't have that information, and probably the starting pathway is to identify who the current fund auditor is. If the trustees don't have that information, start with the auditor, start with the new fund administrator, and see what documentation they have. And I think this was also a classic example of a two-member fund where you had one member who did all the decision making of the fund and did all the transacting, and another relatively passive member, and the active member passed away.
Yeah.
And so the passive member wasn't aware where anything was stored, or didn't have all that information. And so again, I think it's one of those critical things that we need to be mindful of, is that one, and we'll talk about storage and that a little bit shortly, but one, where are copies kept? Even if it's an electronic version, where are copies kept? Who has access to that information? And does that information stand the test of transfer? So transferring administrator to administrator, or whatever the case may be. So pretty critical one, that one, and I hope that they get the right resolution out of it. But just to reiterate, I definitely didn't have the pension documents in my possession. Estate planning. So as I talked about in the spill for this webinar, we did talk a little bit about estate planning, or the entirety of the last webinar was about estate planning. But I wanted to address again the concept of death benefit nominations, and knowing that because of the Hill versus Zuda decision in the High Court, that a self-managed super fund is not required to follow the prescriptive measures of binding death benefit nominations in accordance with the SIS regulations, unless the deed stipulates that it has to, right? And we've had two, I guess, fairly significant cases, and there's more and more cases always coming up in this place that certainly highlight the key issues associated with what the requirements are. And we know that the requirements of the legislation require that the nomination is only valid for 3 years. It must be witnessed by two independent parties, and there's some other conditions in that there as well. But if we looked at Donovan versus Donovan, and this is one of the earlier death benefit cases, right? The form of nomination had to, in accordance with the deed, follow the statutory requirements, right? And then in the deed, it defines statutory requirements, meaning the requirements imposed under any law or by any statutory authority, which must be satisfied by a superannuation fund, etc., etc., etc. And so what that case determined was that the court said that the deed required you to follow the SIS regulations in accordance, or in order to make the binding death benefit nomination. And so they determined that the nomination in that case was not binding because it wasn't witnessed by two independent parties. It didn't mention the lapsing clauses or whatever there. Whereas if we look at Munro versus Munro, in this instance, the form of the nomination had to comply with the relevant requirements, and the deed defined relevant requirements, meaning any requirements, including the provision of the SIST Act, which the trustees or deed must comply with to avoid a contravention of the requirements, etc., etc. But here, the importance being here that the case determined that the relevant requirements did not import those 1617A requirements, because it was not a necessity. And when you look at that definition of relevant requirements, saying that you must comply with to avoid contravention. Now, a super fund doesn't have to comply, or self-managed super fund doesn't have to comply, so therefore they felt that it was not linked back to 617A. So what that ultimately tells us is that in most of these situations, we need to be far clearer in our deed with what we're saying the requirements are for binding death benefit nominations, so that when we then go and prepare nominations, we're actually preparing them with far greater clarity, right? And I know one of the questions that we get, and I know that the SuperGuardian binding death benefit nomination has evolved, or the template, because we don't prepare binding death benefit nominations. That's an obligation on the trustees. But that nomination has evolved as to what requirements it has with regards to servicing the notice or serving the notice on the trustees. Those elements have been changed a little bit there. There's not the strict adherence as it would have been 5 or 6 years ago to say things like the 3-year requirements and that as well. So
I think also, like, just out of it's good general practice to so we send out renewals every 3 years anyway. So it's just a good sort of touch point to say, have to review your binding death nominations, even though it's not required to. It's just a good practice touch point to check in. Family relationships change very frequently.
Absolutely, and I think that's such a valid point. In that when we talk through the concept of what are the best practices, I think that's a great idea or great practice, because legislatively we're required to review the investment strategy. Right now, in some funds, the investment strategy may never change, because our investment horizon might not change for many years, but our personal circumstances might change significantly in that period of time. And so, I think that the fact that the legislation doesn't require you to review the binding death benefit nomination, I think it's still a good practice to be able to continually check in on it and make sure that it's meeting your needs, because it's not going to be front of mind. And then by the time that it's needing to be reviewed, it's too late because someone has passed away or something, and it might not meet the conditions. So I think that's a really good point to make there. So it's one of those key things that as I said up front, and we'll probably say it 1 or 2 more times throughout the presentation, like the importance of the deed with regards to a number of these issues is pretty valid. So look, what I want to spend the last sort of 10 to 15 minutes, or not quite 15 minutes on, is this concept of document signing and storage. Now, there's a little bit, I guess, not uncertainty in regards to this, but it's an area that I know that we do get questions on. I get them. I know that you get them from a client manager point of view as well. But we can never be completely definitive on it, because it's going to come back to that statement that I've been making all along, which is check the deeds. And I still think that deeds are continuing to evolve with regards to a lot of these areas. But to start with, let's touch on the concept of signing documentation. And so what we know is, because of COVID-19, there was the thought process of how do you get everybody to sign things, right? Because if people, particularly when people were in lockdown and they couldn't move over, borders or even boundaries within borders, you can't leave your 5 kilometres, or you can't go outside 5 kilometres in Victoria and some of those places. And so there was all these sorts of conditions that were introduced there. And what that did was it sort of elevated or escalated the need to contemplate electronic signing of documentation. Now, it wasn't perfect, but obviously, as you said earlier, it triggered the escalation of a lot of these sorts of areas, and so this term that's been coined, modernising business communications, has sort of evolved from that. And the first piece of legislation, which was the Corporations Amendment Meetings and Documents Act, which allowed companies to execute certain documents, including the deeds, in a technology neutral manner, which meant it gave us the capacity to be able to undertake this electronically versus wedding. Now, most of these changes, to sort of be sort of upfront about, are fairly significant with regards to corporate trustees. And because a lot of the changes have occurred through the Corporations Act. So the SIS Act is still lagging a fair way behind. And so we basically have to take an approach that in most instances, and I say most instances because I'll highlight the other ones, but in most instances, a wet signature, so an actual signature on a piece of paper, is still required for self-managed superannuation funds. Now, that's not to suggest that you can't sign something and scan it and send it on to the auditors or to the tax office. That's not the issue so much, but it actually requires that wet signature. So, what we do have is we have this Electronic Transaction Act, which basically says if a Commonwealth law requires you to give information in writing, provide a handwritten signature, produce a document in material form, record or information, then the Electronic Transaction Act allows you to do these things electronically. Awesome. However, it applies to all Commonwealth laws unless there are specific exemptions within that the regulations from 2020, and of course the exemptions to that free for all, the Corporations Act and the SIS Act. Okay, so that ultimately provided this issue where it's saying, okay, well, we can do everything electronically unless we're operating under the Corporations Act or the SIS Act. Which two pieces of legislation do we deal with most? Corporations Act and the SIS Act. So it became a bit of a problem. So this basically means that we just have to do everything in a paper form unless there are certain other exemptions or other legislation in place. And one of the things that has come about from all this, and again, it's currently before Parliament, and I made sure I checked this again just immediately before coming into the webinar to make sure I hadn't been surprised with the legislation passing, but I suspect there would have been a bit of fanfare if it had have. We've got this Treasury Laws Amendment modernising business communications and other measure, which is proposing to amend the Corporations Act to enable all documents under the Act to be signed electronically, and certain documents to be sent in either hard copy or electronic form. So we know now that deeds are okay with regards to being signed electronically, but there are other documents and things like appointment and removal of trustees and other things which do require that wet signature soon, so trustee consent to act as director of the company. And sort of where I'm heading with this is that a lot of these documents are replicated in the SIS Act under our trustee requirements. And so where we're heading towards is a place where the Corporations Act will come first, and we'll be able to appoint members and directors, we'll be able to consent to act as directors, we'll be able to resign as directors, all these sorts of elements that are spread throughout the Corporations Act. We will be able to do these sorts of things electronically, but we have to be mindful that that from a SIS point of view, we're only dealing in corporate trustee land there. We're not dealing in individual trustee space. And so, there's still going to be a requirement and a little bit of a lag, as I said before, for those with individual trustees. Now, we know that represents less funds than corporate trustees. And potentially, I wouldn't say that this is when in talking pros and cons of corporate versus individual, wet versus digital signatures is probably not high up on the list as to the pros and cons, but it could be if this other legislation does take a little bit longer to sort of transpire. But there's other issues that come associated with the concept of electronic signatures, and that is that self-managed super funds, we still have a fairly old age demographic among SMSF trustees, and how many families, I can think of a few just off the top of my head of people in my own life have one email address for the family. And so when we're contemplating such things as doing electronic signatory, we might be using something like what is it that SuperGuardian used to have the financial statements signed?
DocuSign.
DocuSign. So DocuSign requires an individual email for each trustee.
Just an individual email. So often you see like your trustees having the same email address, like mum and dad. and yeah, it's real common practice.
Yeah, yeah, and so that's sort of the space where we go, okay, well, to really embrace this, then more people need to be able to embrace technology and have their own email addresses or whatever it might be, just to make the process less cumbersome. Otherwise, we end up being in a situation where we still probably end up getting wet signatures on certain documents.
And for some people that might just work still. But
absolutely. And I mean, I know a lot of people that like to actually be able to read through things in front of them rather than on a screen.
Yep.
And all of these changes, what they won't do is they won't take that away.
No.
People will still be able to do that. It'll just simplify certain processes. And as the systems are built that provide greater security around proof of identity and things like that, it's going to potentially benefit the industry as such. But what we need to be mindful of is that from an SMSF point of view, there's key issues that we do need to take on board, and that is from an electronic execution point of view, there's ultimately only one document. Well, there's two documents, because the second one is the financial statements, which of course the financial statements come under the Tax Act, and Tax Act is an exempt act under the Electronic Transaction Act, and so we can sign our financial statements by using DocuSign or whatever it might be in that situation. But everything else, other than the deed, which has been allowed for under that change from the Corporations Act, our consent to act as a director, well, that's on the list waiting for that approval, but we've then still got our consent to act as trustee of the fund, and I'm going to provide a list in a moment of all of the various sections that require some form of signing or some form of declaration or some form of minute taking from an SMSF point of view. So we can see there that there's a lot of areas that still require a wet signatory, or at least a deed that stipulates the terms and conditions as to how documents are going to be undertaken. So our ATO trustee declaration, which first and foremost has to be signed within, 21 days of becoming a trustee of the fund since 2007, has to be wet ink, right? There's just no ifs, buts, or maybes about it. But then everything else, our member applications, our trustee minutes and resolutions, our BDBNs, it's all going to come down to what the deed says. Right. Now, things like the investment strategy is, and I think probably what we're looking at here is that under this process, where the next stage is reviewing the SIS Act and SIS documentation, is a chance to tidy things up, because one of the more annoying questions that I get thrown at me in the industry is, the law doesn't say that the investment strategy must be written. It just says you must formulate and give effect to an investment strategy. It's like, yes, but if it's not written, then how is an auditor going to review it? How are the ATO going to review it from an audit point of view? So there's an assumption that it needs to be written in that sense. And so all of these areas can hopefully be tidied up. So not just the signing, but also the requirement for it to be in written or electronic format and stored in a certain way that's easily retrievable. All of these sorts of things become fairly relevant. So we know from an SMSF point of view that basically the only thing we can currently really use the electronic option for, or in its simplest form, is the account and the financial statements, and then satisfying our requirements there. And again, there's some references to the ATO that highlight some of these key issues. But from an overall and a more broader point of view, these are all the sections inside the SIS Act that gives us some form of requirement to keep records in the fund. And I've broken this down to round out the session for you in a moment. But again, we've got our auditor requirements from our retention of records there. We've got our in-house asset written plans, as we touched on before, the duty to keep minutes and records, whatever those minutes and records might be, trustee declarations, appointments and removals. So all of these various things, the investment strategy, and the collectibles and personal use. If you're going to store collectibles and personal use assets, then you do need to have a written record. So that one says written record, and store it for at least 10 years. So all of this sort of stuff we hope would be encompassed in these announcements about self-managed super funds and changes to the SIS Act with our record keeping and our signing requirements. But what we do know is that we've got to keep for 5 years, and this is straight from the ATO, so this is straight from the horse's mouth as to how records need to be kept. Accurate and accessible accounting records that explain the transaction and financial position of your self-managed super fund. Documentation showing decisions made about what benefit payment type was paid and the account the payment was paid from. So this comes back to that pension commencement. The ATO are basically putting it out there on their website that you need to show whether it's a lump sum or whether it's a pension and which interest it came from. So we should be documenting that and keeping records of that for 5 years. It's not a formal process from the legislation, but the ATO are saying, make sure you give that to us. So it's pretty critical there. Operating statement, your financial positions, the annual returns, transfer balance account reporting, pretty much any financial records need to be kept for 5 years. And then the decisions about meetings of the fund and any meetings of the trustees, appointments and removals of trustees, pension commencement, all those sorts of actual resolutions that the trustees need to be made or need to make, they must be made and maintained for 10 years. So what we would hope to see is that through the advent of better storage facilities, better signing opportunities, and clearer signing opportunities, that people can retain that information for the appropriate point in time. So, look, what I would say is the key takeaway issues from today's session is make sure your documents are appropriately aligned to the fund's governing rules. And what I actually thought about, Ben, was I actually thought about making that as the only point on this final slide. But then I wanted to sort of identify the other two key issues, despite the fact that we could have spent a lot more time talking about things like appointment and removal and stuff as well. But from a pension point of view, it is critical to get your pension documentation right to avoid any potential for challenge that the income stream was established and managed correctly. So that's the example that I had. Hey Tim, where are the pension commencement documents from 2004? Well, you need to go back and seek that out. Now that's outside our 10-year period, but it's a fairly critical piece of information to be able to maintain and have on file to avoid any potential conflict or court issues. And in estate planning, well, we know that most court cases that we hear in the SMSF space are linked to estate planning and the payment of death benefits. And so we want to make sure that our nominations and things are drafted in accordance with the deed. So, look, great opportunity. Thanks for sort of giving me some of the practical insights from a SuperGuardian point of view there, Ben, with reference to just even key takeaways like what you said earlier. They're the important things, resending out the binding death benefit nominations, all that sort of stuff, all pretty critical. Understanding that what the auditors want might dictate what we actually have to do. So be prepared to prepare additional documentation to support your transactions. And the other key one that you raised was that related party transactions are generally the most problematic, and so the more you can document there, the greater capacity you've got then to satisfy the needs of the fund auditors. So thanks for joining me today, Ben.
Thanks for having me.
And look, if anyone's got any questions, we'll stand here awkwardly for another sort of half a minute. But otherwise, thank you all for joining us, and we look forward to catching up with you next month.